I, Mitchell Clout, am a citizen of Australia over the age of 18 and have personal knowledge of the facts stated herein, unless stated on information and belief. And if called upon to testify to those facts, I could and would competently do so as set forth herein. I am the owner and director of Koil Content Creation Pty Ltd, Koil, which is a community of mod servers known as Nopixel, and which is a collection of multiplayer mod servers that allow members of the private community to play the game entitled Grand Theft Auto 5 with other community members in custom roleplay scenarios. In April 2020, Danny Tracy acquired an account on the Nopixel server. He joined as an unpaid volunteer. Between April 2020 and May 2021, Mr. Tracy voluntarily provided his developer services to Koil. In May 2021, I offered, and Mr. Tracy accepted my offer to have Koil pay him $10,000 per month for his services as a developer. I am informed that TOVE is claiming that beginning in October 2021, they employed Mr. Tracy and then entered into a loan-out agreement with Koil for Mr. Tracy's services. This is false. My only agreement was with Mr. Tracy. At no time ever did I enter into any agreement for TOVE to loan out the services of Mr. Tracy to Koil. At no time was I ever informed by Mr. Tracy or TOVE or anyone else that he was performing said work for TOVE or on TOVE's behalf. I never even heard of TOVE until this dispute began. I would have had no need for TOVE to loan Mr. Tracy's services to Koil. Mr. Tracy had been working for Koil since April 2020 and paid since May 2021. During the period that I paid Mr. Tracy, there were no salary payments made to TOVE, save for two $5,000 invoices that Mr. Tracy submitted for payment that had TOVE's email on it. Mr. Tracy immediately informed me those invoices, which I paid, were submitted in error, after which the payments were reversed, new invoices submitted, and were paid. All such payments, without exception, were made to Mr. Tracy's personal PayPal account. The foregoing payments began in May 2021, when we started paying Mr. Tracy directly via deposits to his personal PayPal account, totaling approximately $10,000 per month. At no point did Mr. Tracy or TOVE ever inform me that Mr. Tracy began working for TOVE and that payments should be made to TOVE rather than Mr. Tracy.
Nopixel is one of the most popular GTArp servers in the world, but in the background there has been this brewing lawsuit over who owns it. Now this lawsuit has been going on for over a year. In the public, we know it's XQC, Buddha, and Koil.
Koil owned 100% of Nopixel. Me and Buddha came in. Koil now owns 50%. I own 25%, and Buddha owns 25%. And together, we own the whole Nopixel world.
Well, Koil has been in this bitter lawsuit between that one video company over ownership of the server because of the work that DW did. Originally, Koil lost on his motion to dismiss the case. The judge ruled that there was a controversy and ruled it as a joint work was performed on the server based on the evidence presented at the time. Later on, Koil would also lose in his motion to compel, whereas he was forced to show all the earnings from the server from 2020 to 2023 and even through the second quarter of 2024. Now, Koil would get a small victory in the form of TOVE having to turn over all of their visa information and communications with DW, which will come up later in the case. Fast forward, there's been a lot of confusion where people thinking that Koil actually won because of this motion going around that's awaiting the judge's signature. Now, if you read it, this motion is presented before the court on October 21st, 2024, which has not happened yet. But because of Koil's post, a lot of people thought that he won. Now, fast forward, TOVE actually tried to steal half the company in a motion for summary adjudication. And this happened on the 12th that they filed this. And here is the evidence that no one has yet to be seen because this is the first time I'm covering it. And I can't seem to find it anywhere on the internet. Now, as we get into it, we all know this is about the undisputed that Daniel DW worked for TOVE, but in working under TOVE, he was working for Nopixel. The stories really don't align. If you ask Koil, he will say, hey, I had no idea. Desperate not to have an account of co-owner for half the profits derived early year from multi-million-dollar video game server, defendants make several arguments that lack any merit or logic and are obviously intended solely to confuse issues. Defendants claim that they have perpetual license to Mr. Tracy's contributions, but cannot produce any writings of such evidence. Now, here's the thing. This is going to come up later because there is a shred of proof that Koil has provided. Now, defendants also claim that they did not know about the loan out agreement for Tracy's services, but that is probably false and unnecessary to the court's analysis. Anyway, according, this motion must be granted, and a determination that TOVE is the co-owner in defendant's video game server must be found. Make no mistake, they're coming for every little thing. We know about Tracy's $105,000 year salary. TOVE and Tracy also agreed that in such a position, Tracy could be loaned out to third parties to render services as a lead developer. This is also going to come back. Because Mr. Tracy was a foreign national working for TOVE in the United States, TOVE also sponsored Tracy's visa application. This is also going to come up later in the document, later in this case. Now, since the commencement of this lawsuit, however, defendants, which will be Koil, have changed that policy and now require all developers to execute a separate written agreement. Now, in this agreement that is presented, it says, the providers of the service provide this website service are not responsible for any users' contents or accounts, but the most important part is right here. You are granting us, which is Koil, or Nopixel, a non-exclusive, permanent, irrevocable, unlimited license to use, publish, or republish your content in connection with the service. You retain the copyright over the content ID. Essentially, it's, hey, thank you for joining the Nopixel server. We own all contributions. Now, that's going to come up later as they argue about if DW's contributions fall under this license agreement. Daniel Tracy's work on the Nopixel server. When Mr. Tracy began as the developer, however, he did not execute a separate written agreement with the defendant Nopixel and addressed his anticipated contributions to the Nopixel server as developer. This is true, or is it? Because according to DW, he was able to sign up through some backdoor services because the server only allows people with 3 characters and his name is DW, which is 2. So someone had to do something. But due to the commercial success of many of Mr. Tracy's contributions, or on or about May 21st, defendant Clout offered to formally pay Tracy to render development services for the Nopixel server. Although initially hesitant, Mr. Tracy further inquired about the opportunity. A few days later, the parties ultimately agreed to a $10,000 per month for his services as role of developer on the Nopixel. On or about May 27th, defendant Clout offered to memorialized the terms and agreement with a separate written contract, but no such contract was ever prepared or executed. This is also true because it was Discord messages. During this time, Mr. Tracy created entirely new code base for the back-end information system of the Nopixel server, utilizing code connect third-party systems to the server to create service features for the server that included without all this right here. Now, here's the thing, right? Nopixel, approximately 80% of the back-end code. And because of his contributions, defendant Koil acknowledged defendant Koil agreed to make Tracy a 50% partner on the server. Now, this is as TOVE is telling the story, but we're actually going to see the Discord agreement, and this is going to be not true. Because we know the server has like 170 servers. Daniel Tracy's termination by defendants. We're going to see Koil's words exactly on why he was terminated. When it goes to the legal standard, a court may grant this summary judgment if the moving party can show that there is no genuine dispute of material fact, and the moving party is entitled to a judgment as a matter of law. Now, here's the thing. The facts are already up for dispute. And the reason they're up for dispute is because they have not yet been proven in court. So they want some declaratory relief. Anytime you see someone saying declaratory relief, they just want money.
Hide the money, y'all. There's poor people around.
Okay, summary adjudication must be granted as plaintiff's first cause of action for declaratory relief. They're using the source code as subject to copyright protection, which this is true. And they're arguing a joint work of authorship based on Tracy's contributions. Now, they're reiterating that defendant Nopixel's contributions made up of 80%. So they're saying Tracy did 80% of the code belongs to Tracy. Defendants will argue that there is other developers involved with the development of the Nopixel server, but it's undisputed that DW was the primary contributor to the creation of the back-end code. This is going to come up a little bit later, but this is just listen to their argument. Mr. Tracy's contributions to the back-end code were so significant and important that the defendants did not remove Tracy's code after termination. So now they're saying, hey, his code is still up there. And they hired an expert and they say Mr. Tracy's contributions still made up of 40% of the back-end code. And now Koil, his expert, is going to argue that no, his code only makes up 0.57%, amounts to the modicum of creativity contributed to the development of the Nopixel server. That's where it gets sticky, because if you fired the guy, his code should be gone, but they're saying, hey, it's 0.57%, which means that his code is still used. Take that as you may. And if you see me skipping a lot, it's because it's really not important. But if you want to pause the video and go read it, have at it. Mr. Tracy did not execute any written agreement that would have granted defendants rights in his contributions. Mr. Tracy never signed a written agreement conveying to the defendants his contributions to the development of the Nopixel server. This is correct because they have no contract per se. All right, they have no contract. Second, even if he could have been in a meeting of the minds between the parties at a time, Mr. Tracy agreed to the terms of service regarding developer servers. Mr. Tracy had not yet offered formally provide the terms of service, were far too vague to be enforceable. Defendants contended that they had a license in Mr. Tracy's contributions because the terms stated that Mr. Tracy was granted a non-exclusive, permanent, irrevocable, unlimited license to use, publish, or republish your content. And the big argument is, does that apply to code? Third, it's not even clear from the record that Tracy agreed to the terms of service when the defendants alleged that he did, particularly given that Mr. Tracy does not remember agreeing to them. So just because he doesn't remember doing it, does that necessarily mean he didn't? That's going to be for you guys to be the judge, jury, and focus subject matter expertise. Defendant Nopixel also paid TOVE for Mr. Tracy's services, even though some of the payments on such invoices were also paid directly to Tracy. Now they're arguing that Koil paid them. However, this may be a little bit misleading. Defendants' inflammatory baseless claims of immigration fraud should have no bearing on the court's analysis. So if you guys don't know, TOVE is accused of committing immigration fraud as a pay for stay, which is also going to come up later in these court documents. It's been over 1,000 pages, and I'm going to try to condense this to as small as I can. TOVE does not seek a determination of exclusive ownership, and finding that TOVE is a joint owner in the Nopixel server entitled to an accounting of all profits and losses generated therefrom. The court should understand that TOVE does not also seek a determination that is the sole exclusive owner of the server. They just want half, okay? They just want half. TOVE defendants insist that the determination regarding TOVE's first cause of action necessarily means that the court will be determining whether defendants have infringed on TOVE's copyright in the server. But this is not what TOVE seeks. To the extent that the charging allegations in the first amended complaint suggest that TOVE also seeks determination of its ownership in the server to exclusion of defendants. TOVE hereby expressly waive such requests. So they're basically telling the judge, hey, we're not saying that we own it. We're just saying that we own some. Based on the foregoing, TOVE respectfully requests summary adjudication to the plaintiff's first cause of action, the first amended complaint, for declaratory relief. All right, so that's that right there. Now, let's get to the statement of DW. This is his sworn statement. Sworn statement, guys. He swears by this under penalty of perjury. So right out the gate, okay? He says, hey, I do not remember applying to the standard application process or accepting the terms and rules set forth in the Nopixel website. Remember, this is TOVE trying to get the money from Koil. Okay, so this is their argument. We're going to get to Koil's argument too. And we already know that they lost on this, but you guys have to see the evidence, okay? Because I was employed by plaintiff, but I was not an American citizen, plaintiff agreed to sponsor my visa application. This is also true that TOVE did sponsor his visa application, but he had already started working for Koil. This is where it gets murky for me. When I entered into employment agreement, defendant Clout knew that I was working as an employee for plaintiff because I told him. Additionally, The terms of my arrangement with the defendant Nopixel changed because plaintiff started invoicing defendant Nopixel for services, and at least a few of my monthly payments were paid directly to plaintiff. I was also elevated to the position of lead developer. Now remember, this is according to DW, not necessarily Koil on board saying the same thing. All right, so as I go through his server, as I go through this statement, remember, I'm only skipping things that I don't find important, but you can pause it. Furthermore, defendants have since accused me of causing a data breach to the Nopixel server after I was terminated. However, I still never seen any evidence supporting this accusation, despite the negative effects such as serious accusation could have on my career as a software developer. There's your boy, DW signature. When it comes to this form, this is their expert. So they had an expert go through and look through everything to see, hey, what the hell, whose code is whose? And his name is William Francis. Now, I don't need to get into the weeds about his background or what they use. I am not a software developer. I got no technical experience. I've been retained by TOVE to see how much of DW's code is still being used or was used, all that good stuff. And we could just go down to his conclusions, because I'm not getting into the weeds. Like I said, it's been over a thousand pages of this, right? Back and forth. Based on his review and analysis as of December 15th, 2022, Mr. Tracy was the primary contributor for the backend code found on the defendant's repositories, contributing to 80%. So initially 80% of the relevant code located therein. After December 15th, 2022, the defendant's repositories continued to evolve, but as of March 14th, 2023, roughly 90 days later, Tracy's DW's contributions still accounted for 71% of the backend code. But as of May 15th, 2024, he is still according to TOVE's expert, 40% still there on the backend code. And look, he is aware that TOVE is saying no, it's only 0.57. And he is aware that, that their person, Gary Kitchen, comes to this conclusion by comparing DW's code against both the backend code and the game code stored on the defendant's repositories. However, he sees no logical reason for evaluating DW's contributions against the combination of both types of code, because plaintiff is not claiming any ownership in Tracy's contributions to the game code, only the backend code. Now, the backend code, if you don't know, is strictly for payments, okay? Strictly for payments. Now, he goes in detail of why Mr. Kitchens is wrong. And when we get to Mr. Kitchens' statement, is pretty much going to be the same thing. We kind of jump away at the beginning, but this is a 108-page statement from their lawyer. Now, look, I am not about to go through 108 pages. We don't need to go through 108 pages. We really could start this at page 62. Okay, 62. So right then and there, just want to let you know, TOVE's lawyer is deposing Koil. And he says, hey, in the first 6 months of 2024, they're talking money. They're talking money. I'm talking like big money. They talking life-changing money. Hey, how much did you gross revenue did Nopixel, the server, generate in 2023? And Koil's answer is like, hey, towards to the end, it was possibly making 70 to 80K a month.
Get your money up, not your funny up.
But at the start, I can't remember. So it could be it could be 1 million, I guess, but I'm not 100% sure. God damn, they get money.
What do you do in a situation like this when you help somebody personally, right? Give them like 400 grand or some shit like that. 500, I don't fucking know how much it was. It was enough money that this guy's like, juice and magoose it. I helped him get his visa. I signed for some shit to get him his visa. As soon as he gets it, he just flicks the fingers, right?
Money. This is life-changing money right here. All right. So they go on to talk about that. And now let's skip to page 72. And this is where they talk about DW getting terminated. Now, look, their lawyers do not like each other. They do some penis jokes, snide remarks about penis going back and forth, but we'll get to that later. So question. Okay, Mr. Clout, When did you terminate Mr. Tracy from his role as developer for Nopixel? When he wanted to leave? Would that have been, I think, December 22nd? Would it be December 28th, says the lawyer? Around that time, yeah. Why did you terminate him? Because he wanted to leave. What is your understanding of why he wanted to leave? Now, Koil is taking shots right here. He threw a temper tantrum, not being able to manage things that he wasn't meant to manage for like the 4th or 5th time, and I didn't entertain it. And he left, said he wanted to leave. So you terminated it. We agreed at that point that it was done. So you didn't terminate him. You agreed to mutually agreed. Is that your testimony? Well, he wanted to leave. So yeah, I just want to get it clear. You mutually agreed that he would leave or you terminated him. Well, he said we weren't going to work it out. And who do I hand over the details to? So technically he left. That's your testimony? Yeah. Yes or no? He was like, yes, look, the lawyer is low-key badgering Koil. And look, guys, I don't know Koil. I don't know DW. I'm just calling it how I see it. All right. Thank you. How did you notify him that he was terminated? Like I said, we agreed. That's not the question I asked. How did you notify him that he was terminated? He agreed in Discord and he sent over the details. And I said, we don't need them. We already had them. So it's your testimony that you notify him over Discord. Yes, we agreed on Discord. He was like, hey, strike everything after yes. Because they don't want this part in there about Discord because Discord plays a key role in this, and this is just more back and forth.
He doesn't really talk after the controller change, and I'm like, okay, I'll give him breathing space because it's not the first time he's flipped out over some shit. I just thought this one was a little absurd, and I just let it be. I talked to him. He gave an ultimatum essentially. We need to resolve this and listed all those things. Things like fuck. Gun changes not being good, not liking how the gun meta is turning out. But from what I see, like the feedback with pistols and shit is being a lot better. So, how policing was. There's a few names I don't want to bring up, but I have my grasp with police and I like a certain police standard. He's different apparently, but that changes every 3 months for whatever reason. And he's pretty much said, I'm either gonna leave or you're gonna do all this right now, or that's just it. So I could understand, we work on things slowly and try to fix things, and that's my logic. I just don't think it's logical to be like, hey, let's do all this right now, and that's just how it is. You know what I mean? Like I just don't I don't understand what you do in this situation. And like I said, the reason I brought up the personal shit is because I feel like I was helping this guy as a friend greatly, and his response is, after all this shit that I've done for him, here's an ultimatum. All the money you did for me was worthless. Helping me get the visa was worthless. Helping me get into streaming and paying me for no reason was worthless. Do this or eat a dick because you didn't like a few changes. So I mean, I don't know what you guys would do in a situation like that. No matter how much of an asshole you think I am, I don't know any logical person that would be like, yeah, listen, I'll give you a hand job for me in the ass. Okay. Why not, dude? You know what I mean? I don't know. I don't know what anybody would do.
Now, when we get to right here, this is the terms in service agreement where they say, hey, you're granting us right here this permanent irrevocable license right here. So this is the terms in service, as you see right there. But does that apply to developers or does this apply to just people using the server? You be the judge. Now we can fast forward to page 77 where they start talking about money. Now this is rather interesting. This is exhibit 10. I don't need to go for this word for word. Long story short, Koil and DW are making bank, making so much money. They don't know what to do with it. Well, basically, hey, let me give you this money before everyone else takes it. Koil says to DW, is it still pulling good money? Don't know money. Koil, yeah, it's given so much to others. Koil says, just do it. If you don't want it, donate it to a charity or other people. All this crass stuff back and forth. You guys can go through it because we have a lot to get through, a lot to get to. But long story short, Koil at some point was, I guess, paying DW through donos, through Twitch. But we'll keep going. He didn't like that because, you know, you're losing so much money. And at this time, DW was making like 30,000 in subs himself. So this time, Nopixel is pumping. Now, here they go where they start talking about the job. DW says, realistically, if I quit my job and siphon some donations to work full time for Nopixel, how much per month do you think that would be? Koil says, I have to look how much I've donated, but to be honest, I give more to you over others. We could also talk Twitch about a buff in your contract if you considered streaming more. I think I've gifted like 80K at least, and that's with a big buffer at the moment. So I don't know how much you need, but yeah, still looks like you do 80% of that ish. DW, just need a rough figure so I can figure out what I need from Twitch to make it worth it. Now, this is where Koil offers them the 10K. I could drop 10K a month easily for a year minimum, probably, then pump more while it's hot. Also depends on if I keep giving to others too, but it's sort of back to Sky Alex only. 10,000 USD? Koil's like, hey, I'll probably quit Monday, but I still need to figure out the visa-ish and need to figure out payment stuff here because he's about to start working for Koil before he starts working for TOVE. When you say payment here, you mean Nopixel? I'm down for writing a contract, or we, if it eases your penis. Need to define we both want out of it, I guess, DW says. Well, basically, just need to know how we're going to handle it and what to expect so I can plan my life around that income and not current. Koil, yeah, just doing, we do now really come up with the ideas to implement them. I'm not trying to do it like 500,000 hours a day of pure coding or some ish. Yeah, what we doing about money? Did your accountant confirm yet? Yeah, it doesn't really matter. This is one of the payments that you see that went from an invoice that was sent from that one entertainment company to Koil. Now, we don't need to go through all of them. We can skip to page 87, where we get this phenomenal letter that Koil wrote on behalf of Tracy, or DW, getting his citizenship. Now, it looks pretty standard. I don't need to read all of this, but like I said, if you want to pause it and read it, have at it. But the good part, best part about it is when we come down right here, where he talks about, you know, Mr. Tracy is the mastermind behind Nopixel's heist system, which he designed and implemented himself. Many times during the heist progression, Nopixel would garner over 500K concurrent viewers on Twitch and other streaming platforms. Without a doubt, I would say the heist system is the hardest to get right. Mr. Tracy has perfected it. Mr. Tracy has also been responsible for our international expansion offerings, translation engine throughout the game. Our entire user experience interface was also overhauled by Mr. Tracy. These are only a few of Mr. Tracy's numerous contributions to which have been critical to Nopixel's success. The significance of Mr. Tracy's contributions is further demonstrated by the success of modifications made in Nopixel. So he is like, hey, look, man, this guy is writing some good code for Nopixel. We need him to continue working in the United States, which is odd considering Nopixel is an Australian company. We fast forward to this, right? Remember, they're looking for half based off the evidence that I presented. Half ownership of Nopixel. Koil responds. They waste no time responding. Defendants notice a motion to dismiss First Amendment complaint. They're like, no. We are not having any of that ish. Now, here's all these statues and all this other crap, but they don't want Nopixel to they don't want to lose ownership. So they say, hey, look, the motion should be denied for the following reasons. It's undisputed that Mr. Tracy granted the defendants a non-exclusive permanent license, and they're about to show you their evidence, so it's not like you're not going to see it. There was never an interim intention by the defendant or by Mr. Tracy for his contributions to be considered a joint work. TOVE did not loan out Tracy to work for a defendant. Mr. Tracy was working for a defendant for over a year before Mr. Tracy began working for TOVE, which is true. And when you see TOVE's contract, you're going to be like, what the hell is going on? TOVE is not in the business of loan out employees. Defendant never asked TOVE to loan out Tracy to it. Defendant never spoke to TOVE about a loan out agreement. Defendant never spoke to Tracy about a loan out agreement. There are no written loan out agreements. There are no documents of any kind expressing any intention to loan out DW. At all times, defendant paid Tracy directly into his personal PayPal account. Mr. Tracy never paid any salary he received from defendant to TOVE. So they're like, look, man, you never paid your money to TOVE. Like they keep going, defendant never paid any money to TOVE. There were two $500,000 payments mistakenly made to Mr. Tracy's account, TOVE account, and they were both immediately refunded. So this is, the paperwork don't lie. Mr. Tracy acknowledged that these were sent by mistake. When TOVE applied for the H-1 visa for Tracy, Jacques Koil, TOVE CEO, stated under penalty of perjury that Tracy would be employed full-time solely at TOVE. Now, this is where the fraud stuff is immigration fraud allegations are going to come to play. Mr. Tracy's contributions to the Nopixel server constitute 0.57% of the code, so they stick into their argument. Defendant never offered to give Tracy 50% of all revenue from the Nopixel server, even assuming that the defendant had agreed to give Tracy 50% of the Nopixel revenue. Defendant never agreed to give TOVE 50% of the revenue, as the defendant never had any communication with TOVE. For all these reasons, the motion should be denied. So they look, man, we gave you hella reasons to deny the motion. Now, we know that they eventually do get the motion denied, but how did they do it, right? How did they get it denied? Let's go and look at their evidence against them, because what you guys see, you get to see everyone's hand. Everyone's cards are out on the table. They harken back. Hey, in 2020, there was an agreement that granted Koil the non-exclusive permanent license via the terms of service. So they're, hey, look, we got the terms of service. Content defined as services as all content you submit, uploads, otherwise make available to the service. So they're putting everyone, hey, developers, users, anyone who does anything, that terms of service applies to you. DW admit that he joined the server in early 2020. Doesn't deny that he agreed to the terms of service. He just says he doesn't remember. Okay. They point out a statement. He says he doesn't recall. The plaintiff's argument that the term TOS doesn't apply to Mr. Tracy because the terms don't say applies to players and developers is a nonsensical argument. The terms unambiguously state they apply to all content you submit, upload, otherwise make available to the service. So they look, man, they going, hey, TOS apply to everybody. They go on to talk about this. Plaintiff has presented no evidence that it's a joint work. Now, when it comes to a joint work, it has to be, they're going to go through it. Okay. It has to be undeniable that neither party, however, the evidence is clear that it's undeniable that neither party considered Mr. Tracy to be a joint author of the code on Nopixel. Now, I don't play Nopixel, but hey, you can make out for what you want. A joint work is work prepared by two or more authors with the intention their contributions be merged into a separate or independent parts of a unitary whole. That's debatable. They bring up a great example. I'm not about to read all that because we got way more stuff to go through. Way more, but best believe, should this go to trial? These are all the arguments that they're going to make at trial. Nopixel server is controlled by Mitchell Clout. He's ran the server since 2016. The company is owned and controlled by Mitchell Clout. Tracy was one of dozens of the contributors to the Nopixel server. All of these people are overseen by Clout, who was solely responsible for overseeing the coordination of the work and content submissions, as final say over all changes and additions to the code on the Nopixel server. Mr. Tracy did aid in building in-game mechanics and reviewing development ideas. That is no way made Mr. Tracy the lead developer on anything other than many contributors. DW at best contributed less than 1% of the total code on the server. Furthermore, when the dispute arose between Tracy and Mr. Cloud, his relationship with Koil and the Nopixel server was terminated, something that could not happen if he actually shared joint control over the work.
That's a truthful statement.
Mr. Tracy lacked control over the work, and absence of control is strong evidence of the absence of co-ownership. Accordingly to the first sector, weighs strongly in the defendant's favor. There are no objective manifestations of shared intent to be considered as co-authors. Look, man, all this saying is, hey, with regards to the second factor, not only are there no objective manifestations of a shared intent to be considered co-authors, all of the evidence shows that the parties did not intend it to be considered co-authors. Tracy will retain a copyright of ownership of all his contributions to the Nopixel server, but that he is granting Koil a license to use the contribution. There could not be a clear manifestation of intent not to create joint work. Even if the court believes that there's a question of fact to whether DW agreed to the TOS, the terms are clear and objective manifestation of defendant's intent alone are a reason to deny the instant motion. Like I said, TOVE is looking for half of the company, half of the entire Nopixel server. So when Mr. Tracy states that TOVE owns the copyright to his code, not that it was a joint work in which both TOVE and Koil own the copyright, that is the end analysis. Both plaintiff TOVE agree that the code written by Tracy is owned either by Tracy or TOVE. Neither party claims that it was a joint work, which I don't think they do. This really is like I hate to say like bad faith cash grab, but when more evidence comes to light, you will see, you may see it. You may be team DW, you may be team Koil. I really don't know. Like, this is completely a wonky lawsuit. His contribution to more than 6 million lines of code were at best 0.57% of the total code. Remember, they're arguing DW or code. Koil is arguing total code. They're just arguing back-end code, which you're going to see is just a payment system, literally. His contributions were not to the creative part of Nopixel, but were merely code allowed Nopixel's API to interact with TBEC's payment platform. Here we go. While it's necessary that the defendant be able to get paid, that is not why customers come to Nopixel. They come to play the game, something that DW made no contributions to. An analogy to Mr. Tracy's argument would be if the person who created the code that allowed Netflix to take credit cards then claimed they were the co-authors of thousands of hours of movies and television series that they had nothing to do with. People come and use Nopixel services because of Mr. Tracy's services, and such third factor also weighs strongly in defendant favors. So to be considered a co-author, a person must take more than a de minimis contribution. Argument number 4. Like, this is them laying out all their cards on the table, which we're soon going to see their evidence. There was never a loan out agreement for Mr. Tracy services. Now, this is very, very dubious stuff right here when we get to the evidence. Plaintiff claims that it owns the copyright of Tracy's work, which we know. We know he began working for DW in 2020, and in May 2021. He was paying them $10,000 per month. They was making so much money. However, Tracy wanted to remain in the United States, so he contacted TOVE to see if it would sponsor his visa. Defendant, being an Australian company, did not care where Tracy worked. Tracy had the ability to make additional money by streaming on the Twitch network. So Tracy entered into an illegal agreement with TOVE, where TOVE would sponsor Tracy's visa, falsely claiming that it was necessary to hire a non-immigrant foreigner to do this work, and in exchange, Tracy would pay TOVE out of his streaming income his alleged salary of $8,750 per month, plus 30% of everything he made in addition to the $8,750. We're going to see his contract. We're going to do a little deep dive in it a little bit later. What plaintiff is alleging is that there was a loan out agreement for Tracy's services, despite the fact that Tracy was already employed full-time by the defendant. Defendant never agreed to a loan out agreement, or was even told that such an agreement existed. And defendant continued to pay Tracy his salary directly to him after the alleged loan out agreement took place. They go in on the visa. And why the visa is so important, because only 65,000 visas are issued per year. And they talk about how COO Jacques Koil stated under penalty that Tracy was to work full-time for TOVE as TOVE's developer. They are going at him. They're going at Koil very hard, okay? But it's basically saying that, hey, You guys are running a pay for stay system and it's illegal. That's their argument. Once plaintiff, now number 5, once Tracy became an employee, plaintiff began invoicing defendant Nopixel for Tracy's services under the loan out agreement. And some of the amounts set forth those invoices were initially paid to plaintiff. So we saw the invoices, they were for $5,000. Now they call out Koil again for not presenting any details what the alleged arrangement was, how he arrived at it, and when it was entered into or who agreed to the arrangement. Of course, this is because no such arrangement existed. But considering so much of the plaintiff's motion is based on this alleged agreement, the absence of any details is further evidence it did not exist. They keep going on about this loan out program. There's no evidence of an agreement and it's legal. So look, the conclusion, this is where, you know, it gets a little spicy. Then we're going to get directly into some evidence. Mr. Tracy is not John Lennon to Koil's Paul McCartney, the Bernie Taupin to Koil's Elton John, or the Hal David to Koil's Burt Bacharach. He is one of dozens of developers who contributed to the Nopixel server, and his contributions make up best 50% of the total code minus minuscule amount. The idea that his tiny contribution to allow him or TOVE to be considered a joint author is without merit. There is zero evidence that the party intended for the server to be considered a joint work. Instead of all the evidence shows that it was never such an intention. Plaintiff respectfully requests that the court not only deny plaintiff's motion, but that the court holds it as undisputed that there was no joint work and dismiss the plaintiff's first cause of action outright, as there is no remaining trivial questions of fact regarding this matter. What do you guys think of this shit? I think it's crazy, but let's continue, right? We got to continue into the statement of Larry Zerner. Larry M.F. Zerner, please say the F, okay? So this is his sworn statement where he's just about to just provide a bunch of evidence. Now, the first piece of evidence that you're going to see is the contract that DW signed for that one video gamer company. Now, we don't need to go through all of this where they talk about the salary, right? Here's his salary. He's making $105,000 per year. It'll be payable in periodic installments according to the company's standard payroll. Now, this is where it gets murky, all right? Sponsorships. The company shall retain 30% of the gross amount paid for sponsorships, and you should be paid the remaining 70% of the gross amount paid for the sponsorship, subject to unless payroll deductions and withholdings required by law. Now, when we get down to ownership right here, ownership of intellectual property, this number 8 is what their entire lawsuit rests on. During your employment with the company, any creative or intellectual property developed and originated by you in performing your duties for the company will be company property. You will not, without an express written agreement signed by the company CEO, have any right to the property. Now, think about this. This guy has been working for you for a year or so. All the work he does, all of a sudden his visa is on the line. He wants to stay in America, even though he can do this job from anywhere in the world. He wants to stay in America. Well, he signs this contract, and according to DW, he told Koil, "Hey, I signed this contract." Even if that's true, right? Even if it's true, did he say, "Hey, by the way, anything that I work on, they own"? Probably not.
Nope.
So let's keep going, because if you would have told him that, you fired a guy on the spot and you addressed that right away. Now let's keep going. This is, is more of the contract. This offer, if not accepted, will expire at the close of business on October 31st, 2021, which coincidentally, right? Let's get to the sworn statement of none other than Koil, right? This is Koil's sworn statement. He owns 100% of Koil, okay? I mean, I thought Buddha Next UC owned a portion, but I think they own a portion of the server, not necessarily the company per se. In 2020, Danny Tracy acquired an account in the Nopixel server. We know this. 2020. The terms, hey, non-exclusive, permanent, irrevocable license. We know this. Tracy agreed to the terms and service. We're going to see that exhibit 2 when that comes up. He agreed to them. or someone agreed to them. I obtained this document by going to administration page for the Zenforo forum, which lets me see the status of all persons who have an account on the Nopixel server. We're going to get to it. Don't worry. Now, he swears that, hey, he never intended that DW or TOVE be a joint author. Nopixel code. That's why the terms of service expressly state that the contributions continue to fully own the code that they submit. They're just providing Koil with a license to use the code. I never told DW or TOVE that I considered them to be joint authors. And prior to this lawsuit, Mr. Tracy never told me that he considered himself or TOVE to be a joint author. He had never ever said anything like that to me. I would have immediately told him that was not the case, so there would be no confusion. In fact, I have never had any agreement whatsoever with TOVE, nor have I had any communication with TOVE, whether orally or in writing. And I was unaware of their existence or alleged involvement in ownership and content in any content until this lawsuit. The only agreement I had was with DW in connection with ownership or licensing content within the terms. Contrary to TOVE's claims, DW was not the lead developer, nor was he responsible for managing the work of other developers or handling technical operations, infrastructure, or development. Now look, guys, DW certainly was not anytime primary contributor to the backend code of Nopixel server. Okay, his work was a small percentage of the overall work performed by many other developers and was always under my management and control. There were 10 other developers working for Koil on the Nopixel server. DW was never credited as co-author on the server, nor were any other developers, which is another truthful statement. The credited owner of the Nopixel server is Koil. I have also been made aware that Mr. Tracy and TOVE claimed the nature of their claim work was to build payment processing system. Nothing could be further from the truth. In fact, all the times, even before DW began making these alleged contributions, Koil utilized third-party platform provider TBEX to process payments. The only work Tracy performed, therefore, was limited to creating some additional code to facilitate interactions with the TBEX payment platform. In the agreement Koil had, work was never with TOVE. At no time ever did I enter in any agreements for TOVE to loan out the services of Tracy to Koil. At no time was I ever informed that Tracy or TOVE or anyone else had performing work for TOVE or TOVE's behalf. The first I heard of them was this lawsuit. Now, the big one. Neither did I ever enter in a contract to pay TOVE 50% of Nopixel's revenue. Further, we got to keep going. The only arrangement Koil had with DW and Tracy alone. In fact, for these services, Koil agreed to compensate Tracy and Tracy only, who was paid directly. He goes on to say he never paid TOVE, was aware of their existence, save for 2 invoices that Tracy submitted for payment that TOVE's email is on. Still, Mr. Tracy immediately informed me that those invoices, which I paid, were submitted in error, after which the payments were reversed. New invoices submitted were paid. All such payments, without the exception, were made to Tracy's personal PayPal account. So you guys kind of get the picture. There was no 50% partner. We did agree to give Tracy revenue share for four servers of the mini Nopixel servers. So 4, namely priority queue sales of the white priority server, the India server, the Spain server, South America server only, while he was working for Nopixel and delivering promised products, helping the infra team in developing 4 mods monthly, 1 including Red Dead Redemption, which never was completed. That was it. And while this argument was in writing on Discord, there was no written oral argument with anyone at any time. Koil would pay Tracy or TOVE 50% of all servers, otherwise make a partner. In addition, oh gosh, he wants to talk about the leak. In addition to the foregoing, I wish to address the claim as stated in plaintiff's separate statement of undisputed facts that Mr. Tracy was a talented developer and I defamed him. First, DW was serviceable as a developer, but no more talented than the dozen other developers that were working for Koil. More importantly, however, at no time did I defame Mr. Tracy. Now, it's interesting that he said that because in his letter to the government that was written, I believe, in 2022, he did hype him up as saying he's the mastermind. So look, man, hey, it is what it is, okay? Let's keep going through. Let's get to another exhibit. Now we're looking at depositions of William Francis, which is the quote unquote expert, which is the COO of TOVE. This is where he's trying to make the argument of the pay for stay. Wasn't DW required to stream enough that you could clear the $8,750 a month that you were paying him? And of course, TOVE lawyer objects, assumes facts, not in evidence. But Jackie says, look, I wouldn't call it a requirement. It was for both our benefits that he streamed to earn the income and the donations, so he could, not only could we pay his salary, we could cover his salary and operational costs, but that he could also make more money on top of that, which is weird. Like, look, here's the thing, right? If he's making money streaming, why does he have to give it to you? Why is that part of your salary? Is streaming part of him working for TOVE? Were you taking his streaming money? He's hired as lead developer. That streaming money is completely apart from development, right? All right, now look, look, man, these lawyers gonna object to everything. I disagree, so said the witness. A lot of his development was done while streaming, or a lot of his customization and some of his work was done during streaming. So he's basically saying, no, he's streaming coding at the same time, so that's him working for us. Now look, Zerner ain't no fool, so he keeps pressing the issue. So if Danny got $10,000 and he gets the first $2,000, then you get the rest, right? Then you still split it up afterwards. So he's trying to basically hone him down. So traditionally, the way it works is the management firm would collect the money from what are generally like marketing or influencer agencies, so like an MCM. So they would collect the money. They would take their fees and any cost they had on there. So if they were FedExing stuff or Ubering things, sometimes you have, products and stuff. So they would take their cost out and that would be sent to TOVE, where we would then take our percentage out and then hold the rest and send it to DW at a later date. And when he got the money, so the employment agreement says that TOVE is only entitled to 30%, but when he got money, TOVE would actually take the first $8,750 or 100% of that money before they did the 70-30 split, correct? Jackie is on the ropes. I don't know if I would characterize it like that way. You would have to look at it from like an engagement of all of the income that was coming in for a month. The salary was the base, plus I think there were some operational and overhead, which Danny had agreed upon. I think that was like, $1,250, like that number should be aiming for a bare minimum. Anything over that, not only taking my 10% covering the cost, but it would be extra bonus money for him. If there was a sponsorship deal, like using your example of $10,000, will receive $8,000, I would take into account. We would account for the $3,000 and then Danny would take the extra $5,000 as a bonusable income. Hey, does this make sense to any of y'all reading this? Right. So if you only make $10,000 in a month and it's a single month from streaming money, did TOVE keep all of that? Objection. The witness says, I would also say that it never happened. Yeah, it never happened until the end of 2022. I think we also at some point agreed that end of summer or maybe the beginning of the fourth quarter, and that's the end of his testimony. But what do you think so far of the evidence that he presented? I believe we went over Clout's statement. Now we have the declaration of Gary Kitchens. Now this is going to be their expert. Now look, it's 46 pages. No way in hell am I reading that. We're going to do like we always do and just go to the conclusions because he gives his resume, what devices he used. Like I said, if you want to stop and pause this to, for all the programmers out there in the chat, summary of findings. Look, page 8. Page 8, he's standing on business. Mr. Francis' methodology, which purports to assign percentage of contributions to the overall project of Mr. Tracy's code, is incorrect and fraught in inaccuracies. Based on my calculations, more accurate percentage of the contribution of DW's code as compared to the entire Nopixel project is 0.057%. So he's always going to compare the code to everything as opposed to the code used on the back end, which, you know, is going to bode well for him. But like, this is way too technical for me. But I know we do have like some people in code that probably want to see this report and go over it, but we just have to focus that, hey, the back end code, they're focusing on all the code. And he goes on to kind of explain why William Francis' report is inaccurate versus the accuracy of his report. But like I said, I'm not one of these ninjas out here. This is the order for summary judgment that's going around. Now, here's the thing, guys. Their motion for summary adjudication was denied. And like I said, it was denied based on the fact that the facts have still been, they haven't been disputed yet. But here's the bigger picture, right? Koil, this lawyer, is crafty. Larry Zerner is top tier, right? So they have this hearing scheduled for the 21st. And he like, look, defendant's reply brief in support of motion for summary judgment. You like, wait, what is this? This is them saying their time is up. See, what happened was on September 23rd, 2024, Koil filed the instant motion for summary judgment per the court rules, which I do have a copy of it. And TOVE's opposition brief was due to be filed no later than September 30th, 2024, 21 days to the October 24th hearing date. Plaintiff did not file any opposition brief to the defendant's motion. Accordingly, defendants request that the court enter summary judgment in defendant's favor, as there is no issues in dispute. So Larry Zerner is like, look, man, they didn't respond in time, which means everything we said is true, and they agree. Now, as technical as this is, and even though it may be in Koil's favor of them not responding, I don't know if this is going to work. In the present case, you know, the plaintiff has not presented any evidence to convert the now undisputed, now they're saying all their facts is undisputed, that Tracy granted the license via the TOS, there was never a loan out agreement, and that the code Tracy contributed to the Nopixel server was not a joint work. Thus, neither Tracy nor plaintiff can be considered a joint author. Now, here's the thing, right? I checked the court docket. This is today. This is October 16th as I'm recording this. And there is nothing in there at the bottom. Nothing in there at the bottom. Like nothing whatsoever. I'm like, they filed this on October 3rd. You would think you'll get a reply. Here is the defendant's notice of motion for summary judgment. It pretty much wraps up. It repackages everything in there. However, there's one kicker in it, right? There's one like, oh man, because if you go through this, right, and you like, well, what was it? What did they file? You see Mitchell Clout's statement again, where he basically regurgitates the same, but this is a declaration of Benjamin Lau, okay? He's an attorney licensed to practice in the state of California. You're like, well, who the hell is this Benjamin Lau guy? He works for a law firm. What is he? He is the immigration counsel for that one entertainment LLC. Okay, so he's like, yo, he's the lawyer for TOVE. And he says, look, I can confirm that I, immigration counsel for TOVE, had no conversation with that one video entertainment regarding the existence of a loan out company. That one video entertainment never informed me of the existence of a loan out company or any agreement with a loan out company. Now, look, man, I don't know if this is going to be the smoking gun that is needed to secure the case or anything like that. But it is telling that you have all this. And I don't know, guys, what do you make of this? Like I said, I don't know DW. I don't know Koil. I don't know anybody. But this is very telling to me.